recorded when I started doing the introductions, but I forgot. But anyway, so now we've done the introductions. Can I also just cover some of the housekeeping? If I could make sure that each of you stays on mute during the presentations. We'll be taking questions after both presentations. So Ruth will do her presentation first, followed by Rachel, and then we'll open it up to questions and discussion. So please do keep a note of your questions and hold them to the end. You can put them in the chat if you wish. And again, I'll address those after both speakers have a chance to do their presentations. I don't think there are any other housekeeping items. Please, for the questions and discussion, I would encourage you to turn your cameras on, just so we can actually see everybody and engage in a proper conversation as much as is possible online. So we'll go ahead and make a start. The webinar is being recorded, as you heard, so it will be available for people who want to listen again, for people who aren't able to, who signed up but weren't able to attend. So it'll be available, and we'll be putting it on the INCCIP website as well. So please do have a look at that. If anyone wants copies of the slides, if you contact INCCIP, again, it's info@incip.org, then we can make the slides available as well. Kate, I'm going to give you a personal apology because I saw that you'd signed in early and then I'd actually accidentally admitted you and then I had to kick you out again, and now you had having to come in last minute. So I appreciate your patience with my brutal reception to your attendance. But it's lovely to have you here. Right, so I'm going to go ahead and pass over to Ruth, who you'll have seen her biography on the advertisement for the webinar. But Ruth is an advocate, a lecturer, and a former coordinator of the University of Malta Human Rights Platform, and has been involved in all sorts of incredible human rights-based work throughout the world. And as I said, was recently a presenter at the Children of Prisoners Europe conference in Malta. Well, you're actually speaking to us from London, I believe, Ruth. So welcome, and I will unpin myself and Rachel and hand it over to yourself.
Obviously. Okay. Sorry about this. I have lots of pop-ups coming up. Okay, here we go. Can everyone see this okay?
Yes, that's great. Thanks.
Lovely. Okay. Well, thank you all very much thank you, Nancy, for inviting me to contribute to this webinar and join you at INCCIP for this short time. So as Nancy said, my presentation today is based on some work prepared for the COPE meeting earlier this year. And the focus there was about dismantling the concept of stigma and its impact on children whose parents are in prison. There were some very interesting and thought-provoking conversations during that meeting, not least of which, in my opinion, the input by people who very generously shared their life experiences as children of parents who spent time in prison. But my interest is on what was originally the subtext to the conference, and that was about children's rights standards. So my questions, and what I hope to tackle in this very short time, are what exactly are those standards? How may each and every child access them? And what are the easy routes for children to go about accessing those rights, those standards? And if they can't, then what are the duties and responsibilities of adults and NGOs to help them get there? Because it's all very well to assume we understand the standards, and indeed all of you here, I'm sure, and most of the people impacted may well know them. But for a child, even if they do know their rights, it's often a challenge to actually access and enforce those rights effectively. How many children are we talking about? So I always look at updates on numbers. There are very few EU countries that record data. An estimated 310,000 children every year have a parent in prison in England and Wales. But I see from the INCCIP site that 3.8 million children have an imprisoned parent in the US. That was at 2019. And 2.8 million children in China. It's absolutely staggering numbers. One thing we know for sure is that this is an issue that impacts the lives and well-being of countless numbers of children at any given time. So when a parent enters the criminal justice system, there's no set mechanism for the concerned authorities to be notified whether those people have children, or to keep records regarding whether a prisoner has children. To my knowledge, in Malta, for instance, where I originally come from, we still don't have a system of keeping count of children of prisoners. And of course, prisoners themselves may be very reluctant or unwilling to share this information, and there's a variety of reasons, some of them good reasons. But little effort is made to establish the truth. There's some new light on the horizon. In Europe, the Child Rights Guarantee recognizes that children affected by parental imprisonment need integrated rights-based responses, and they're going to introduce a new indicator, or they're proposing to introduce a new indicator, ensuring that children with a parent in prison can access integrated support services. And I know that COPE has been at the forefront of pushing for this. So the standards, to start with the obvious, the CRC. There's a whole list of rights regarding basic right to life, survival, development, the right to non-discrimination, the right to have their best interests considered in all decisions affecting them, the right to maintain contact with their parents, the right to be heard. All of these rights under the CRC. But I know Rachel will speak much more about this, so I'm going to leave the topic in her very able hands. And I know that you're all very conversant with the CRC anyway. The Council of Europe has done some great work standard setting for children whose parents are in prison. There are some excellent organizations and researchers working in the field. And of course, tied in with that, there's the European Convention on Human Rights in the Court. And I'll come back to the guidelines on child-friendly justice. And then from a child rights standard access viewpoint, there's ENOC, there's the European Network of Child Ombudsmen. And that's a very interesting group. And we'll come back to that. And I noticed that on the webinar today, there are a number of people from ombudsmen's offices. At the UN level, the committee's taken the lead in providing guidance on the treatment and rights of children whose parents are in prison. So the committee recognized children being at particular risk in their 2005 comment. And then in 2013 general comment, again, specific reference. But of course, it isn't just European. Child rights standards apply in loads of other parts of the world. The African Committee of Experts on the Rights and Welfare of Children issued a study about the implementation of decisions regarding the welfare of these children in May 2003, and made specific reference to a specific country that I won't single out, regarding the way that they were providing for the rights of children whose parents were in prison. There's also an Australian Human Rights Commission, which subdivides into loads of different commissions. So they deal with that as well in their own particular way, probably, possibly, undoubtedly, in response to very specific needs of their own population and the children in their cohort. And the Inter-American Commission on Human Rights. And there is a special rapporteurship on the rights of the child. And then, of course, in Asia. So all throughout the world, there is a focus on human rights standards. And of course, if you're talking human rights standards, then you need to also talk about children's rights standards. But what does this mean in practicality? I come from Europe, so my example is going to be European. And the example I'd like to share with you is a 2019 case decided by the European Court of Human Rights, which emphasized the fundamental importance of considering the best interests of the child when arresting parents. So this was about a 10-year-old It's A versus Russia. There is the reference at the end of my presentation. There are the references. This was a case about a 10-year-old who witnessed her father being violently arrested outside her school. And the court said, but you should have known that she would be able to see this happen. Why didn't you make provision for this to be done better? So in the context of children of prisoners or children of those facing possible incarceration, best interests assessments need to be incorporated. At what stage? Of course, children need to be aware of their rights if they're going to exercise them, but they're likely to depend on adults. This presentation is largely directed to children and young people who look to discover their rights and the standards, but also to adults who accompany them along this journey and empower them to access those rights. And I've mentioned all the various possibilities that can be used here. So on many occasions, the response to any questions set by a child is that the professional will make a decision on their behalf in their best interests. And they will make this at these different points. At the point of arrest, about the sanctions that may be going to be used, whether someone should be detained before trial or allowed out on bail, about conviction and alternatives, and at the worst possible scenario, at the application of the death penalty, whether a child should actually go into prison, or having been in prison, remain in prison. And also about financial issues, whether the caregiver or the person in prison is going to continue to receive financial support, because sometimes this is also contingent on imprisonment. So I ask, when are standards most supportive to the child? And these are some of the instances. It's not exhaustive. I'm sure you can come up with more, but standards are important when their parent is being arrested. What can they do about it? How can they be treated more respectfully during that period of time? When the parent is detained, when there's visitation issues. There's one really interesting bit of research about children's reactions during COVID, when, because of COVID restrictions, children were not allowed to visit at all. What happens there, and I have another little case I want to share with you about what goes on inside a child's head when they are not permitted to make contact at all. So in all of these instances, these standards could be supportive to children. Of course, access to rights for children assumes that they know about their human rights, and they know specifically about their children's rights. They might live in a country where they have access to OP3, to the optional protocol on a communications procedure. So they might be able to actually go directly to the United Nations Committee on the Rights of the Child and bring up their issue there. However, that isn't every country in the world, and actually there's quite a few countries in the world. And then, of course, the most important, to me anyhow, in practical terms, is human rights institutions for children. How do children access those standards? And it's usually by an institution set up specifically to represent and help children, because they're the people who can help guarantee the child a seat at the table, where the decision will impact the child's present or future well-being. This is echoed in the Council of Europe guidelines on child-friendly justice. And there are a number of cases of the European Court that also demand now separate representation for children, whereas the assumption would have been that, of course, if you are a child, you are represented by your parents. The idea now is that, children have the right to be represented individually. And more than that, if there are more than one child in a family, then those different children may have different needs and may require different forms of representation. And that can be cumbersome, but it's certainly worth thinking about. And from the child's perspective, it's worth taking into account very, very seriously, because if you have more than one child trying to access their rights and trying to use the standards available to them, they may not all have equal access. They may not all have equal knowledge as well. So probably one of the most recent changes in this whole scenario has been this child impacts assessment documents, which are being thought up, worked on, researched. And they're not about assessing children, they're about assessing the needs of children. They're not about the parent who's in contact with the justice system. The focus is on the child and their feelings. Now, I come from a family law background, and the difference in application and interpretation of this responsibility to listen to children always really stands out for me. Because in family law, the child separated from a parent is usually given encouragement and support to maintain a relationship, as long as it's positive and in the child's best interest. But for some reason, this doesn't translate well within the custodial setting. A child whose parent is in prison doesn't enjoy the same rights as a child whose parent now lives in another household following relationship breakdown. Why do we use these different standards, and does the child have a right to question those standards? Well, Article 9 of the CRC expects states, I quote, to ensure that a child shall not be separated from his or her parents against their will. And under the European Convention of Human Rights, authorities have this positive obligation to optimize care relations. And when you think about it, this is a very remarkable child rights standard. So coming to ICRIs, which I think is at the crux of what I would like to share with you today. When children are looking for applying their standards, discovering what the standards are, discovering their rights, they will look to, usually invariably, look to adults who know about this topic. And the people, the organizations that are able to do this are independent child rights organizations. They have a crucial role in monitoring legislation and policy decisions. They also need to ensure that children are given priority. They need to act as spokespersons, but they also need to make room for children to be able to deal with the system that they're in, because in the variety of scenarios that I shared with you, where children are dealing with a whole range of people, police, lawyers, social workers, judges, probation officers, prison visitors, prison staff, children are facing the same challenges that we all face when trying to work with the system. And there are a number of barriers to information. There's usually, invariably, a lack of information about the realities of prison life, about the emotional upheaval experienced by families and the challenges of maintaining contact. Sometimes, more often than not, the way statistics may be used can be misleading or downright incorrect, which can perpetuate unhelpful messaging regarding the future prospects of children with incarcerated parents. Some cultural factors would have us believe that there's shame connected to this, and this is a burden for the whole family. So there are also structural barriers which can often lead to separation from the parent or child. So there might be lack of child-friendly visits in prison. There might be a very large distance, a geographical distance between prisons and families. And some prisons may not consider an individual's child needs over security issues. Children have the right to know that they should be able to maintain contact with their parent during pre-trial, during sentencing, and they have the right to access information, have their identity protected, have a right to privacy, and have their psychological needs also respected. So hostile prison settings can be a big issue. Strip searching children in some cases prior to visiting parents. I'm aware that the Prison Reform Trust carried out a survey back in 2019 with children, exploring the impact of these various stages on children. It was focused on mothers who were in prison, but this is a very interesting area to go into, especially for independent child rights institutions who are representing them. So these child rights institutions are all over the world. I mentioned ENOC, which is a European network, but of course there are ICRIs in loads of other countries. Not all ICRIs are truly independent. I say this with great respect, and I point it out because for children, this is quite an important issue. Now, the list is astounding. It could give us a lot of hope in addressing many of the issues that address children. I've added the list, which is published by CRIN on the reference page at the end of this presentation, for those of you who would like to follow up. But there are institutions specifically for children all over the world. And my question is, what elements of that human rights institution make it accessible to children? Where they're part of the state, are they truly representing children? They may be part of a ministry. They may be part of a human rights commission with a very small desk dealing with children's issues. Without a great deal of expertise regarding children, or juggling expertise on children as much as they can within a very limited budget and with very limited personnel. Do children know that they exist? Are children able to access them? So if they have a mandate that explicitly covers children, one would expect that there would be links to official websites, and children would be able to get in touch with these institutions, specifically children whose parents are in prison, but every other child who has an issue regarding accessing their rights and knowing more about the standards available to them. So I just wanted to share one case with you. And I'm sharing this case because it got to court specifically because of a human rights institution, of a child rights institution. Otherwise, it wouldn't have made it to court. Now, I understand that not all child rights institutions have this capacity. Some of them can't even bring cases before court. But in this particular case against Lithuania from 2023, the father was in detention and not allowed to see his daughter for 9 months, and then only very sporadically. And what's interesting in this case is that the court goes into her feelings. She didn't know what had happened to her father. She was worried. She watched TV like lots of other children do, and she thought, my goodness, is my dad being tortured? Is he being locked up? Have they thrown away the key? Is he being kept in the dark? Does he have enough food? All of these issues which a child who is not kept up to date, actually anyone who's not kept up to date with circumstances, might worry about. And she was suffering. The psychologist who was nominated to meet with the child said that the child was suffering from great stress, post-traumatic stress disorder. She told the psychologist that the applicant, her father, was very important to her. She used to spend a lot of time with him, and his arrest, which she'd witnessed, had been one of the most difficult experiences of her life. She said she'd only feel better if her father came back home, but at least she'd accept seeing him briefly, just to know what had happened to him and to make sure he was still alive. And the court really buys into this and says, what on earth can you be using as an excuse not to let the child see the parent? He was in prison on drug-related charges, and the authorities said that letting the child see the father might hamper the proceedings. The court did not accept this at all. But my point is that without the ICRI, this case would never have made it. So coming to an end of what I'm trying to share with you. I don't purport to have answers to all of this. As a matter of fact, I'm really interested to know how you view this. Because at the end of all this, knowing what is available, how can we each ensure that child rights institutions represent all the children in our country? What can we do about it? How can we make sure that they take all of this on board? What tools do you think work best to empower a child rights institution to empower each child? And my 2 cents worth on that is that unless we ask children, we won't ever really know. Which is why we always, all of us here who work with children, know that you need to bring the child into the room to understand how this can actually work in practice. What is most effective? And also, with humility, what doesn't work? If it doesn't work, even if we've invested a lot of time and energy onto it, we need to throw it out. And what else is necessary? What's there that we haven't spoken about? What can we make possible for children to access what is actually theirs? Because at the end of the day, how can a child be empowered to seek out and enforce their rights most effectively? If you'd like to get in touch, that's my email address. I look forward to hearing from you. These are some of the references for those of you who are interested. And as Nancy said, the PowerPoint presentation will be available for anyone who'd like to see it. Thank you.
Thank you so much, Ruth. That's really, really helpful and a great start to the conversation. I think we, as I said before, we'll go straight into the second presentation. Again, if you have questions, please do either write them down for yourself and save them to the end, or you can add them to the chat and we'll put those in separately. So thank you so much, Ruth. And I think I'm almost going to change my mind and say that we'll just send the slides out automatically to everyone who's registered, because I think they're really valuable for people to have. I'm going to move swiftly on to our next speaker, who many of you will know already. Rachel Brett is an international human rights lawyer who's done a huge amount of work based in Geneva, worked with the Quaker United Nations office. I think you're actually back there now, even though you're officially retired. But really looking forward to hearing from you. And I'm going to disconnect myself and share your slides for you. So give me 2 seconds and we'll get that set up.
Thank you very much, Nancy. I'll start and you can put the slides up when you're ready. And again, just to stress, in addition to the slides, my full presentation, if you would like it, my email address is on the last of the slide, and you're welcome to contact me and I can send the full presentation, which includes all the references to the cases that I'll be talking about. So I'm going to actually, as the title says, look at the international human rights jurisprudence, i.e. the case law on children whose parents are in conflict with the law. So that's prison, but also before and after. And also to suggest ways in which you can be using this to advance the rights of the children. And as Ruth rightly said, obviously the major international human rights law reference point in relation to children of incarcerated parents is the UN Convention on the Rights of the Child, to which all states, except the United States of America, are parties. I would just point out, Ruth mentioned the complaints procedure, the third optional protocol. Currently, as far as I know, only 53 states have accepted that. So there are a lot of states that you cannot yet bring cases directly to the Committee on the Rights of the Child. And in fact, so far, the committee has yet to decide any individual cases relating to children of incarcerated parents. Neither at the regional level have the African human rights bodies, as far as I have been able to check, although there is one potential African case. The Inter-American Court of Human Rights has decided 2 cases, but also has a relevant advisory opinion. So by far the most active has in fact been the European Court of Human Rights, which has decided 18 cases which are relevant and have addressed a broad range of issues. In the course of these considerations, the European Court has become increasingly aware of the rights of children in these situations and the need to take these rights into account. And Ruth correctly has identified the Lithuanian case as one of the crucial ones. And just so that we get the record straight, COPE, together with a UK-based organisation, actually did an amicus brief to the European Court in that case, focusing specifically on the rights of the child. The European human rights case law the European Human Rights Convention doesn't have a specific provision on the rights of the child. So it has considered the issues related to children whose parents are or are alleged to be in conflict with the criminal law under Articles 3, no one should be subjected to torture or to inhuman and degrading treatment or punishment, and Article 8, everyone has the right to respect for private and family life, home and correspondence. Specifically, the European Court has found that when an arrest is taking place where children are known to be or are likely to be present, there's a positive duty on the authorities to plan accordingly. When both parents are arrested or detained, there's a duty to take steps to see that any children present have someone to care for them, that the conditions and healthcare in prison or detention must be appropriate for any baby who is living in prison with the mother. The prohibition of or restrictions on contact between children and their imprisoned parent is an interference with the child's right to family life, but it may be justified in accordance with the provisions of Article 8. In this context, the Court has referred to the recommendation of the Committee of Ministers of the Council of Europe to member states concerning children with imprisoned parents. The Court's jurisprudence covers visits, including imprisonment so far from the family that visits are impractical, the ban on telephone calls, unjustified restrictions on direct contacts, and restrictions on the use of the family's own language in person, over the telephone, or in letters. The importance of an individualized assessment in relation to a child visiting her father during his remand, pre-trial detention, rather than reliance on a general ban, and that was the Deltuva versus Lithuania case. Significantly, in the most recent case, the court found that no violation had occurred, having carefully reviewed the provision made for the child to spend time with both imprisoned parents, both separately and together. The courts also considered the conditions for visits in prison, which must not be inhuman or degrading, and the failure to consider in a timely fashion the return of a child to the custody of an acquitted parent. So quite a broad range of issues, although obviously not always as child-centered as we would like, and there are, of course, issues that it has not addressed. The Inter-American Court of Human Rights has considered the situation of such children under Article 5, the right to humane treatment, Article 7, the right to personal liberty, Article 11, the right to privacy, Article 17, the rights of the family, and, of course, under Article 19, which is their one on the rights of the child. Specifically, it has found violations of these rights where, again, prisoners are held hundreds of miles from their family. But unlike the European Court, notably, the Inter-American Court's judgment included a specific reference to the fact that the child should be considered and heard in relation to the location of the detention of the parent, and that arranging occasional visiting opportunities was not sufficient. The Inter-American Court has also addressed the question of nighttime raids on the family home where children are present, and the detention and ill treatment of child family members of the detained persons. And again, the issue of children left without adult care.
Rachel, can I just interrupt for a moment and just say I'm not entirely sure when to change the slides, so I don't know if I'm supposed to be changing. If you can just let me know, that'd be great.
Sorry. Okay. I don't have the PowerPoint in front of me because I'm using a different text. So yes, change the slides. Let's see where we've got to. Can you change, Nancy? So these were the bodies I referred to, the UN, the standards, like the European Court findings. And again, go on, next one. Yes, and then these are the Inter-American standards. And as I say, they have a provision on the rights of the child, which the European Convention does not. Next one, Nancy. And the next one. Okay. So how are these relevant? And this is the first, in each case, of course, the specific judgment applies legally only to the state against which the case was brought. But the significance of these judgments, individually and as a group, is greater. As you can see here, both the European and Inter-American courts have referred to the Convention on the Rights of the Child in their own judgments. In addition, the Inter-American Court has specifically cited the case law of the European Human Rights Court in deciding its own cases, and has also referred to the African Charter on the Rights and Welfare of the Child, Article 30, and its General Comment 1, which is its general comment on that provision, which is the one about children and imprisoned parents. When considering later cases, you could go to the next slide, Nancy, both courts refer back to their previous decisions and so are setting out binding legal interpretations of the relevant convention for all the states who are parties to that convention. So all case law can be used as a basis for subsequent cases and in domestic processes in court. Notably, although the Committee on the Rights of the Child has yet to decide a single case relating to children of incarcerated parents, it closed the recent case of SS versus Turkey because the domestic authorities made the necessary changes to remedy the situation. So the mere fact of bringing the case may actually produce a result without having to wait for the court's determination. In those states who have constitutional or other provisions giving legal status to ratified human rights treaties, for example, Colombia and Argentina are ones I specifically know of, these court decisions can be cited as authoritative interpretations. Next slide, please, Nancy. So here are some strategies that you could be thinking about how to use this case law. If your state is one of those who's been directly concerned in any of these cases, check whether the necessary changes have been made so that the systemic issue or problem does not occur again. Secondly, In all states, if bringing cases in the domestic courts, point out the relevant case law and call for it to be applied to the case being brought, with the tacit threat that if not, further legal procedures could follow. Next slide, please, Nancy. Thirdly, if seeking change through political or parliamentary processes, use the relevant case law to reinforce your demands. Fourthly, if bringing cases to any of the regional or international bodies, including the Committee on the Rights of the Child, not only remind them of their own decisions, if any, but draw their attention to other relevant case law. They do pay attention to this. As I showed, the courts refer to each other's jurisprudence, and equally the Committee on the Rights of the Child may not cite it specifically, but they do pay attention to it. If your state has not accepted the complaints procedure for the Convention on the Rights of the Child, but has accepted the one for the UN Covenant on Civil and Political Rights, which is true for many more states than the ones who've accepted the CRC one, consider bringing a case to the Human Rights Committee using the equivalent provisions to those in the European Human Rights Convention and citing the relevant case law. However, next slide, please, Nancy. I would stress that bringing cases to international or regional bodies can be a long and technical process, including using all domestic procedures first. But the general issues, though not the individual cases, can be raised more readily through the UN Human Rights Treaty bodies' reporting procedures. Not only the Committee on the Rights of the Child, but also the Human Rights Committee, and, where relevant, those dealing with economic, social, and cultural rights and racial discrimination. For these, pointing out any relevant case law is again useful. Specifically, if the case concerned your country and it has not fully addressed the issues, but also more generally, if you want to draw attention to things that you would like the committee to raise with your government and to recommend to them. Finally, the UN also has a system that covers all states called the Universal Periodic Review. This is not limited to those who've accepted any particular human rights treaty, but it is a completely different kind of system. At the international level, it is in fact a public bilateral government-to-government procedure in a multilateral setting. The advantages of this system are that it is more public and can apply more political pressure than the treaty bodies, and that the state under review has to say whether or not it accepts the recommendations. Too often, when the treaty bodies make concluding observations, the state does not necessarily respond to those to indicate whether it is taking account of them or not. The disadvantage of the Universal Periodic Review are that it is political, and unless you can persuade another state, preferably one that your state respects or considers like-minded, to make a recommendation, the issue will not be taken up. I'm going to leave it at this point, but as I've said, and here on the slide is my email address. If you would like the full presentation, which includes the references, or to follow up these ideas, feel free to contact me. Thank you.
Thank you so much, Rachel. That was really, really helpful, as it always is. I'm going to unpin us from the screen, so give me 1 second, and open it up to questions from the group. I would suggest that you turn your cameras on so we can all participate equally and see each other as a group. And I think there's some questions in the chat already. So I'll start with those and then we can open it up to the floor. So we have a question from Sohail. Do you want to ask that question yourself, Sohail, or would you like me to ask it for you? Happy either way. If you wish to ask it yourself, please unmute yourself and do so.
Well, thank you very much for giving me this precious space. I would like that you ask this question to our, honorable speakers.
Okay, thank you. So did you want to ask your question about how we build stronger community support systems in schools or faith communities, local groups? And you're speaking specifically about children with incarcerated parents in Pakistan, is that correct?
Yes, of course. I'm talking about the children who are facing, many problems in Pakistan, because unfortunately, all these respectable speakers have described here, most of them are not applicable in Pakistan and didn't work over here. So that's why I put this question.
Yeah. Rachel or Ruth, do you have any response?
I would make one quick comment. You have many very, very good human rights lawyers in Pakistan. So I think one of the things would be to be in contact with them and encourage them, first of all, perhaps to also help with briefing local groups, including the children and young people themselves, on what their rights are, how they can access any of these institutions that exist, whether domestically or internationally. But also that might help to bring the child rights perspective more into some of the thinking of some of those lawyers themselves.
Thank you. Ruth, did you want to come in at all?
I think the final comment by Rachel is really hits the nail on the head. And I take very much to heart what the gentleman is pointing out. It is a different experience, but unless children actually know their rights and know that there are standards that they should be able to access, and adults take it upon themselves to help them, nothing will ever change. So yes, I'm not trying to gloss over how difficult this can be, but it is possible. I think most countries in the world have started from zero about children's rights. And what do you think you're doing, giving rights to children? It can happen.
Thank you so much, Ruth. We have some other questions coming in. Can I ask Elizabeth from Save the Children to unmute and speak?
Hi, sorry, was just turning my camera on. Thank you so much, Ruth and Rachel. Really, really valuable insights. So I run the advocacy work for Save the Children in Palestine, and child detention is a big part of our programming and advocacy work. Palestinian children are the only children in the world systematically prosecuted and detained through Israeli military courts and in a military court system. We are looking at potentially expanding that focus, both programmatically in terms of mental health support, but also from an advocacy standpoint to children whose parents have been incarcerated, because it is such a systematic tool of the occupation that's designed to fragment basically families and undermine the future of Palestinian society. That much is clear. So with that in mind, we're trying to explore the kind of policy options in this space. I've got a bit of a conundrum that I'd like to put to you for initial reflections. So the domestic track is pretty defunct. Israel as an occupying power has no particular interest in changing its ways or setting up systems to better honour and uphold Palestinian children's rights. The Palestinian Authority that sits under the Israeli occupation apparatus is straitjacketed. It doesn't have the power basically, to push through the occupation. And I was listening to kind of references to the international options, which I think is one avenue for us. The other one that I reflected on as you both spoke was potential to engage states who've got good practices and strong case law, to basically push them to recommend and pressure for these practices in their engagement with Israel. The problem we've got is that we can't actually call for kind of conditional assistance. Let's say like the EU-Israel trade agreement, for instance. We could say you shouldn't be doing these things. There's a human rights clause in there, which is clearly being breached. You shouldn't be, giving them these trade privileges unless you're also, unless they uphold ABC standards. The reason we can't really do that is because the International Court of Justice found the occupation unlawful a year ago, just over a year ago, and one of the legal obligations for member states is that they must not recognize the authority of Israel in Palestine. So if we suggest that they kind of recommend to them best practices for how to conduct their de facto authority in Palestine, it's murky water from a policy standpoint. I'm going to think about it more, but I just wanted to put it on the table. I realize it's a very thorny policy area, but any initial reflections on routes we can explore would be greatly appreciated. Thank you.
Thank you very much, Elizabeth. I'm going to put that to Rachel in the first instance.
I mean, you have a major problem. I mean, there's no question that this is probably the most difficult one. Well, it's certainly one of the most difficult ones. And quite frankly, the UN is not of any use in putting any pressure on Israel because it simply ignores it. So the direct route that for most other states we would look at, the direct possibilities, it's really not worth the time and effort. Except insofar, I mean, I think there's two things. One is on the documentation side. I mean, and that goes back to not that it's going to change anything for the time being, but actually having that documented throughout still has a value to it. Highlighting it to other states, again, has a value to it, although the states that probably have better practice, even if they were willing to use that practice to try and change things, probably currently have no or little leverage with the Israeli authorities because they're the ones who are actually likely to have recognized or likely to recognize the state of Palestine as an independent state. And so, again, you have that, the political problems are so great. I mean, one, you're welcome to get in touch with me and we can go on batting ideas about. I mean, the one thing I just wonder is, I know they're not the same in any way, but are there any equivalent issues that you could use within Israel as entry points or examples of better practice within Israel itself that you could then be using, perhaps together with some of the human rights law NGOs and others, to try and actually shift the balance just a fraction even. And that's my only immediate possible thought on it.
Thanks so much, Rachel. Ruth, did you want to come in at all?
I hesitate to come in here because it really is a huge, huge issue. But I happen to like the UPR. And I keep a little eye on Lebanon. And as far as I remember, Lebanon comes up next year, early next year. And it just strikes me that Lebanon is directly affected by what is going on. So maybe politically, I don't know, Lebanon would include any issues like this in its UPR discussion.
Thanks so much. I think that is one thing that's interesting about the UPR process, though, is that it does involve other countries coming in on behalf of the one that is being examined. So I think that is it can be a potentially very useful kind of additional political pressure in that sense. Just to say, I'm conscious of the time, but INCCIP held a joint webinar with Child Protection Areas of Responsibility a few months ago, specifically on the situation of incarceration of parents, so children with parents who are incarcerated in the West Bank. That recording of that event is held by the other organization, but if that's of interest to you, then please let me know and we'll make sure you get access to that recording. Just one final question from Sohail again about connecting to other international networks or independent child rights institutions. Ruth, am I correct? I think you have a slide about that, or how to access other independent child rights institutions in your slides?
None of my work, I wish I could take the credit. Corinne very kindly put together a whole list of child rights institutions and email addresses. And I have included that in my references at the back. I'm happy to also give a link to the list. It's a very comprehensive list, and I haven't checked each and every one of them out. I've checked a few out, and they do work. So it's great, absolutely great.
That's great, and thank you again, Robert, for your comment as well in relation to the value of this kind of discussion. It's really difficult to find hope sometimes and to find positive practice. So I really appreciate your thoughts on that. Just to say, I never introduced myself. I'm Nancy Laux. I chair the International Coalition for Children with Incarcerated Parents until next month. But we are holding a number of webinars and discussions. We're members of Child Rights Connect as well, which has a working group on children with incarcerated parents. So there are opportunities to continue these conversations and to learn from each other as we go along, because it's quite complex, as you can imagine, and it's so important that we support each other through these types of questions. I appreciate the time has been short for this one. Please do continue the conversation. Make sure that you sign up to the INCCIP newsletter, which you can do again at the INCCIP website, which is just incip.org. So please do join us, and look forward to talking to you again soon. Thank you again to Rachel and Ruth especially, and to all of you for coming. Thanks so much.